In the law of negligence, there are certain types of negligent actions that are given special treatment in the law, and we call these the special negligence doctrines. And there are about 4 of them that are the most commonly known. The first one is res ipsa loquitur, the thing speaks for itself. The second one is negligence per se. The third one is the danger invites rescue doctrine. And the fourth one is statutory special negligence doctrines, like the Good Samaritan laws and the Dram shop laws. So res ipsa loquitur is fun for me because I took Latin, and you're supposed to pronounce it that way, but most kind of cowboy redneck lawyers and judges on the West Coast say, yep, there's res ipsa loquitur. But no matter how they say it, it's a Latin term, and it means the thing speaks for itself. So sometimes, because of the fact circumstances, you can sue for negligence even though you cannot prove exactly what it was that happened. A classic example is you go into the hospital for knee surgery, and you're so concerned that they might operate on the wrong knee that you take a magic marker and you mark on one leg, this is the right knee, and you mark on the other leg, this is not the right knee. And then they put you to sleep in your room, they give you an anesthetic, they lift you out of your bed onto a cart, they roll you down to the surgery and lift you off the cart onto the surgery table. They do the surgery, and then they lift you off the surgery table, put you back on a cart, roll you back to your room, and then lift you off the cart and put you in your bed. And when you wake up, the first thing you do is you check your knee, and oh good, they did operate on the correct knee, and your knee's all fixed, and that's great. But there's a problem, because as the anesthetic begins to wear off, you realize that now you have a broken shoulder. You don't know how it happened. You didn't have a broken shoulder before they put you to sleep. All you know is that they were responsible for the safety of your body the whole time you were asleep, and they must have dropped you sometime during all that, because now you have a broken shoulder and you didn't have one before. So under a theory of res ipsa loquitur, which is Latin for the thing speaks for itself, you may be able to sue them for your broken shoulder, even though you don't know exactly how they did it. You can't prove exactly how they did it, but the thing speaks for itself. So that's the first one of the special negligence doctrines, res ipsa loquitur, the thing speaks for itself. The second one is negligence per se. Now, negligence per se, when you sue someone for an injury caused by carelessness, by negligence, you usually have the burden of proof. As the injured plaintiff, you have the burden of proving that the other person was negligent, that they breached their duty of care somehow. Unless they injured you while they were violating a safety law. If they were violating a safety-oriented law at the time that they injured you, then the burden of proof shifts to the defendant, and there is a presumption that the defendant was in fact negligent because they were violating a safety rule, a safety law at the time that they injured you. Maybe they were speeding, maybe they were running a traffic light. They violated some kind of safety law, and so now there is a presumption that the defendant was negligent, and the burden of proof shifts to the defendant to try to prove that they were not negligent. So that is a shifting of the burden of proof called negligence per se. It's not the violation of any kind of law. It has to be a law that's designed to for the safety of the public, that you violated a safety rule. The third type of special negligence doctrine is the danger invites rescue doctrine. We already discussed a hypothetical of that earlier in the class, but the idea is, even if a person sees the danger that you have left, the hazard you've left on your property, if they assume the risk of going onto the property and facing the danger because they're trying to rescue someone else who has already been hurt there. Ordinarily, under the assumption of risk doctrine, if they assume the risk seeing that the hazard is there, then they don't recover damages from you because they assumed the risk. But that does not apply if they assume the risk to go to rescue someone else who's already been hurt. Under the danger invites rescue doctrine, if you created the danger that created the rescue effort, then if the rescuer also gets injured, you're liable for their damages also. So that's the danger invites rescue doctrine. The fourth special negligence doctrine is the Dram shop, or the statutory special negligence doctrines. One is the Dram shop doctrine, and the other one is the Good Samaritan laws. We already talked about the Good Samaritan laws that say if a medical person stops at the scene of an accident to render aid to an injured person, they are shielded from liability because we don't want them to be afraid of getting sued and be afraid to stop and render aid. But the Dram shop laws are much more controversial and interesting. The Mothers Against Drunk Drivers got on the big campaign about all their loved ones that had been hurt and injured by drunk drivers, and rightfully so. But a couple of the laws that they passed may not have been that logical. People passed these laws in response to public pressure, political pressure put on by Mothers Against Drunk Drivers. And one of them was the Dram shop laws that say, if you own a bar and you're making money by selling liquor, then you'd better have good liability insurance, because if you let someone get drunk at your bar and then go out and drive a car and they hurt somebody, not only are they liable, but the bar owner is liable also. Let's look at that for a minute. In some states, they took the Dram shop law and in response to public political pressure, like the Mothers Against Drunk Drivers, they extended it even further, and they said not only are bar owners liable, if someone gets drunk at their bar and then goes out and drives and hurts somebody, but if you're a private homeowner and you have a party at your house and someone gets drunk at your home and you let them go out and drive drunk and they hurt somebody, you can be sued and you'll be held liable as the homeowner. Well, in my opinion, that takes it one step too far. And in Texas, that new law that extended the Dram shop law to private homeowners was challenged in the court. And, it's interesting because the judges in Texas are not well known for their legal scholarship. But in this particular case, I felt like the judge in Texas gave a very well-reasoned opinion when he struck down the extension of the Dram shop laws to private homeowners. He said, look, suppose you have a wedding reception at your house, and there are 200 or 300 guests there, and half of them you don't even know because say you're the father of the bride, and the other half of the guests that are there are friends and relatives of the groom, so you don't even know half of them, and there's 200 or 300 of them there. And when they get there, they have a couple of drinks at your house. But do you have any way of knowing, with regard to those 200 or 300 guests, whether that's the first drink they've had of the day, or whether they were one of the groomsmen that had 6 or 7 shots with the other groomsmen before they came to your house and they're already halfway bombed or bombed? No, you have no way of knowing that. So is it fair to hold you liable if they go out later and drive drunk and hurt somebody? And the judge said, no, it's not fair. And then he said, secondly, there's 200 or 300 people there. Do you have any way of keeping track of 200 or 300 people and how many drinks they have at your house? No, there's no way for you to keep track of 200 or 300 people, how many drinks they have at your house. And so is it fair to hold you liable if one of them is too drunk to drive and goes out and drive? No. Secondly, do you even know how they got there? Do you know whether they're driving or if they've got a ride with somebody else? Do you even know if they have any car keys or they have a car there? No, you have no way of knowing that. So is it fair to hold you liable? No, it's not fair. And finally, suppose that you do identify one of the guests who's drunk at your house and they say, well, I'm leaving now and I'm going to drive home. Do you have any legal way to stop them if you say, please don't drive, give me your car keys and I'll call you a cab, or I'll have someone else drive you home, and they say, no, I'm fine, I'm taking my car? What are you going to do then? You're going to put them under a citizen's arrest and risk being sued for false imprisonment? You can't really stop them. So is it fair to hold you liable if they go out and injure someone while driving drunk? And the judge said, no, it's not fair, and so this is stricken down, as unreasonable, unconstitutional. So that's the reasoning for striking down the extension of the dram shop laws to private homeowners. But I would suggest to you that if you apply that same reasoning to a bar owner, you come out with the same result. It's a busy Friday night. You've got 200 or 300 people at your bar. Do you have any idea whether this is their first drink of the day or they had 6 or 7 shots before you got to your bar? No, you don't know. So is it fair to hold you liable? No, it's not. Do you have any way of knowing whether, can you even keep track of how many drinks they have while they're there on a busy Friday night when there's 200 or 300 guests in your bar and they're buying drinks for each other? No, you don't know. So is it fair to hold you liable? No, it's not. Do you even know whether they are driving a car, whether they walk there or they have a ride from someone else? No, you don't know that. And suppose you do identify one that's too drunk to drive and he says, I'm driving home, and you say, please don't do that. Do you have any legal way of stopping them from taking their car and driving home? Not really. So is it fair to hold the bar owner liable for the drunk driving that happens to someone that drank at your bar? I would say no. I don't believe it is. But, you know, the Mothers Against Drunk Drivers are obviously going to say something different, and they're entitled to their opinion too.